Hey there, Legal Tea listeners. This is your host, Jenny Roselle. I hope you had an awesome Thanksgiving last week. I hope you also saw the message that I didn't have a new episode last week. So I'm back in your ear this week. And for today's episode of Legal Tea, we have a cautionary tale where we, in these kind of episodes, talk about real life cases, real life clients, real facts. They are things me or my office have actually worked on. So for today's episode, we're going to be talking about a real life story and client, of course, and it's kind of a demonstration of a series of unfortunate events, all because of a slip up that happened many years ago. So let's dive in. My office recently started helping a lady, let's call her Nancy, with her estate planning. And after we presented the various options to accomplish her goals, she ultimately chose to do what we call an asset protection trust, which is an irrevocable trust that protects assets against long-term care and Medicaid. Her main motivation in doing this type of plan was to protect her house, her home, and honestly, that's a frequently stated reason for doing this type of trust. Even when people have little financial assets, they still see the value in protecting their house. And honestly, if you turn a house into a pile of cash, it's usually a hefty pile of cash. So her primary motivation in doing the asset protection trust was to protect this house from long-term care and Medicaid down the road if she ever needed long-term care. You see, our normal process is usually like 3 or 4 meetings depending on the client and their plan, and it goes a little something like this. We first have an initial meeting, which I kind of like to call it our blind date. The who are you? Who am I? What are we doing here? Tell me about your family and your goals and what you're trying to accomplish, and I'll present options that satisfy those goals. So that's that very first meeting, the initial meeting. The second meeting is a design meeting, which I tend to call it the nitty-gritty meeting. And that's the meeting that we decide like who is going where and who are beneficiaries, and just it's kind of the molding the plan to the client. Now, after this design meeting, that's when really a lot of our, backstage, our support team gets involved, and specifically like our funding paralegal. After this meeting, we know for sure whether or not we are doing a trust plan. So like in Nancy's case, we are doing a trust plan. And part of a trust process is doing funding, and that's the process of putting assets into the name of the trust. So the funding paralegal's responsibility after the design meeting is really to start gathering documents and creating documents to get assets into the name of the trust. One of those things is usually a deed to move a house from someone's name into the name of their trust. Okay. So then the next meeting, number 3, is our signing meeting. So of course, that's when we review documents and ultimately sign documents. The fourth meeting, just to tuck back into your brain, I guess, is what we often call our funding meeting. And sometimes it's needed, sometimes it's not. But nonetheless, for this episode, just know that is a meeting that's part of our process. So with Nancy here, she had gotten through the initial meeting where she decided to do the asset protection trust. She had gotten through the design meeting where she decided who was going where and where we molded the plan to her and her family. And we had even gotten to the signing meeting, where that meeting, like I said, is when we review the documents and ultimately sign everything. And that's when things took a sharp left turn, my friend, and not in a good way. Now, remember when I mentioned that in between the design meeting, number 2, and the signing meeting, which is number 3, my office starts working on the funding documents like the deed? Well, at that time, the funding paralegal had pulled the latest deed for Nancy's house and discovered that the house was in Nancy's name and another person's name. And the paralegal kind of flagged it at that point. So when Nancy came in for her signing meeting, the attorney would remember to chat through getting, the other person's signature to be able to move it into the house, into the trust. Well, Nancy shows up for the signing meeting. They get everything signed and they move on to discussing the deed and other funding things. And the attorney inquires about who this other person is on the deed. And guess who it is? Nancy's mother, who is deceased. She actually died in 2011. So deeds are tricky. And like I've talked about on here before, they're really easy to mess up. And that's exactly what happened here. And here's the quick backstory. So the house was actually Nancy's parents' house many years ago. And Nancy's mother had added Nancy's name to the house after Nancy's mother's husband, so Nancy's father, died. They did their own deed. They did not seek legal assistance at all. And the rather frustrating thing about real estate is that it just works a little bit different than, say, like bank accounts. So to clarify, I guess what I'm saying is think of like a joint bank account. If one of the joint owners passes away, the account just legally defaults in ownership to the surviving joint owner. That is not how property, like a house, works. Instead, property gets transferred totally how the deed is written up. And all too many people try to whip up deeds without professional guidance, like Nancy here and Nancy's mother at the time. And they get themselves in trouble because they don't know that there are different types of ownership. And those different types play out very uniquely if an owner passes. So just to expand on what I'm talking about, here in Indiana, and I assume in many other states, there are three, generally speaking, types of property ownership for a house or land, etc. So let's run through them quickly. First, we have joint tenants with rights of survivorship. This means that two or more individuals own the property, and if an individual passes, the property just stays with the surviving individual or individuals. So say we have Bob, Tom, and Cliff as joint tenants with rights of survivorship. Cliff dies. Well, now Bob and Tom are just now own the property. It doesn't go like Cliff's interest doesn't go according to his estate plan or anything. The second type of property ownership is something called tenants by the entirety. This operates just like that, the joint tenants with rights to survivorship, but it's exclusively reserved for married couples. So say we have Bob and Mary. Bob and Mary are married. Mary dies. The property automatically converts just to Bob. Sometimes on a deed, it merely says like Bob and Mary as husband and wife. And if so, in Indiana, it is presumed that it defaults to this tenants by the entirety classification. Now, number 3 is called tenants in common. And this means that every owner owns a respective interest. So let's go back to Bob, Tom, and Cliff. And they own a property as tenants in common. Bob owns a third, Tom owns a third, Cliff owns a third. Say Cliff dies, well, his 1/3 would be distributed according to his estate plan. Meaning, if his will left everything to his spouse, now Bob, Tom, and Cliff's wife are owners of that property. The kicker is that if the deed is silent, what I mean by silent is say it doesn't have any of these classifications on the deed, it defaults here in Indiana again to tenants in common. So when Nancy's mother died, because Nancy and her mother didn't expressly state any of these classifications, Nancy's mother's interest in the house should have gone through probate, and the property should have been distributed according to Nancy's mother's will. Well, that never happened in 2011 or any time until now. So all of this, what I just said, all of this comes out in Nancy's signing meeting that, oh my goodness, now we're going to have to completely pause Nancy's trust to deal with Nancy's mother's half interest in this property. The craziness does not even stop there, though. We, of course, inquire about Nancy's mother's will because Nancy's mother's interest in the property is going to pass through her will. Now, keep in mind that this house is the house that Nancy's been living in forever. Well, fast forward some time and we get a copy of Nancy's will. She had disinherited her 2 other children, Nancy's mother's 2 other children, so Nancy's siblings. And everything in the will was supposed to be going to Nancy, which would have worked beautifully if Nancy dealt with this back in 2011 when her mother died. Annoyingly so, Indiana has a statute, a law, that says if you do not probate a will within 3 years of the person dying, the will is essentially no good, and their estate has to be distributed according to the laws that apply if someone dies without a will. The fancy name is called intestacy laws, which is not ideal because now Nancy's siblings are in the mix, even though Nancy's mother's will disinherited them. The will cannot be probated if it's been more than 3 years since the person died. So that's kind of where we are right now with Nancy. We are starting the probate process to deal with the house, and we will see what happens with Nancy's siblings, the ones disinherited in the mom's will. My gut says this won't go smoothly, but we'll, just have to wait and see. I'd love to be wrong. I would love to be wrong. I think this story teaches us a few things. First, that deeds, while they seem so small and so easy to DIY, do it yourself, they are really, really easy to mess up on. Like I talked about the different types of ownership, that is single-handedly what people mess up on most frequently. Another thing to learn is that anytime someone passes away, please talk to an estate attorney, even if you think that there's nothing to do. You want to know what's crazy and really sad is that had Nancy talked to an estate attorney after her mom passed away in 2011, sure, we would have had to gone through probate, which it is what it is. But then mom's will would have held up because it would have been, of course, within that 3-year window. And because it would have held up, it would have disinherited her other, there's a fire truck going by right when I'm recording. Nonetheless, here we are. Anyways, what was I saying? Mom's will would have held up, right? And it would have disinherited her other kids, meaning the house would have passed to Nancy. And we seriously would not be in the predicament we are in now had Nancy talked to an estate attorney then when her mother died in 2011. So yeah, a lot to learn from this cautionary tale, huh? Cross your fingers for poor Nancy. Like I said, I fear things are not going to go very well with her siblings, but I hope I'm wrong. I really hope I'm wrong. Alrighty, let's wrap this episode up. Next week, we are back to the current events, current trends topic. So something I've seen or run across, or maybe just a timely, relevant topic that I think would be interesting to chat about on here. Well, next week was inspired by one of my team members who, what do they call it? He's a gamer. He plays a lot of video games. Anyway, he was telling me that recently he was playing a game called Starfield. I have no idea if that's a big game, a game that's not heard of, whatever, but it's called Starfield, and it has a level called Last Will and Testament Quest. And he was joking with me that I should talk about it on here and maybe go into details to like what would happen in, quote, real life if a will couldn't be found. So let's do it. It'll be fun. So catch me next week talking about that. And until then, Legal Tea listeners, be well and talk soon.